go back to your answer to Justice Thomas, the purpose of summary judgment is to decide the ultimate question: who owns the car, correct?
Yes.
The purpose of a post-seizure hearing is to determine who keeps custody of the car, correct?
Yes.
And the focus is therefore different. The focus in the in the hearing would be, there might be a disputed issue of fact with respect to ownership. The government might claim it needs discovery. A government might claim it has some facts that would lead to a judgment that it needs to explore. But the court would then weigh whether or not that is sufficient not to give custody to the car owner pending the hearing, correct?
Yes, Justice Sotomayor.
So summary judgment doesn't answer this question, or the isolated question of who keeps custody of the car pending the ultimate judgment, correct?
That's right.
May I ask about that? I'm sorry, please.
No, I was just going to say whether or not summary judgment is adequate, given that difference in the focus of the hearings. I'm presuming that's why you're saying that's not the issue before us. The issue before us is, what of the two tests do we apply to determine whether that's enough or not? Correct?
That's right, Justice.
I mean, if I could ask about that same kind of thing, what the difference is between the retention hearing and the final forfeiture determination. I mean, take a case like this where your client is raising an innocent owner defense. Now, I would think that the questions about whether she was an innocent owner are pretty much the same in the retention hearing and in the final forfeiture determination. Isn't that correct?
I think the substantive question is the same, yes.
Now, there is a different burden, but if she can prove at the retention hearing under a probable cause standard that she is entitled to the car back, I mean, there's no way the government is going to lose on the final determination, right? I mean, she's proved that she's entitled to the car.
I think that's most likely correct. In theory, by the time of the final determination, there could be some additional discovery or investigation that happens that would change the calculus.
Yeah,
but most
I suppose
likely,
in an individual case, but most likely, the government probably would just give up at that point, right? Under this, very generous standard to the government they've lost. They're not going to keep on pursuing the thing. So she's gotten her car back and the case is over. And I guess what this suggests is that in both cases you're really adjudicating the same thing, which is, like, am I entitled to my car back right now? So how is it really different? I understand saying this is interim, this is final, but in the end it's just, am I entitled to my car back now?
Justice Kagan, I think that the substantive question is the same, but there are a few key differences between the retention hearing and the later merits determination. For one thing, I don't know that the premise is correct that the government would just give up if it loses at the retention hearing. Again, there's a different procedural standard later. The government has the opportunity to conduct more discovery. The government also has in Alabama, as well as 25 other states, a financial incentive to keep pursuing the forfeiture proceedings because they get to keep the proceeds. And so I don't know that it's empirically correct that the government would simply give up if it loses at the retention hearing. In addition to that,
I guess what I'm asking is if we've had a case that says, the constitutional rule about forcing a determination about who's entitled to the car is the Barker rule. Why it is that we can say, well, we have that rule, but in fact, there's another constitutional rule which is much more beneficial to the claimant that's meant to address exactly the same question that we held in 8850 was addressed by Barker.
So I think they're different. For one thing, I think they are different questions. As the Second and the Sixth Circuit have explained, in Barker, In Barker, the only question, it was essentially a case where the claimant was trying to argue a gotcha. There was no argument in Barker, I'm sorry, in 8850 or von Neumann, that the government was not ultimately entitled to forfeit the property. There was no innocent owner defense. The claimant's argument there was, well, but you waited too long in order to actually complete the proceedings, and therefore I get my car back. And in that situation, this court said the Barker test applies. There's a different argument where you have an innocent owner defense, where you have somebody coming forward and saying, I should be entitled, as a matter of Alabama state law, the rights that Alabama state law gives to me, I should be entitled to keep my car. And the state can't effect a de facto forfeiture of that car for months or years during the pendency of proceedings.